So here we're going to talk about a very, very important topic within the realm of medical ethics, and that is confidentiality. Now, our laws about confidentiality here in the U.S. may be a little bit different if you're an international viewer, so you might want to pay attention. Please consider subscribing to my Patreon page at www.patreon.com/pwbmd. You can click the link below in the description of the video or on the I button in the upper right hand corner, and it'll link you up. You can consider chipping in $1 a month. A little bit goes a long way to help keep these videos free. If you subscribe, you'll have access to some of my premium videos in which I go over case studies, formulating differential diagnosis, treatment plan, things that'll come in useful for you as you gear up to study for your steps and also for clinical practice. Thank you very much in advance for your consideration. So we're going to talk about HIPAA, the Health Insurance Portability and Accountability Act, which I'm sure if you've worked in any hospital in the U.S. in any capacity whatsoever, you've had training on HIPAA, so you probably have some idea of what it is. It really is the backbone of our confidentiality laws here in the U.S. Then when do you violate confidentiality? So confidentiality really, you have a good idea of what it is. Don't tell things to other people that it's none of their business. And that's generally a good way to approach things. But there are circumstances in which you'll be expected to quote unquote violate confidentiality. And I put it in quotation marks because you're not really violating confidentiality when you do this. In many instances, you're expected to do it. So you need to know these circumstances because these are cases in which not only are you expected to violate confidentiality, but you have to do it. These are mandatory things, and if you don't do it, you can get into some trouble. So it works kind of both ways. And those are things like threat to self or others, reportable conditions, minor patients, and abuse. And then we'll talk also about dealing with minor patients in general. It doesn't all have to do with confidentiality, but I didn't know when I was going to be able to squeeze it in, so I figured I'll just get it out of the way right now. And then we'll recap things at the end. So the Health Insurance Portability and Accountability Act, or HIPAA, is a federal legislation that was signed into law by President Bill Clinton in 1996. Here he is. And this law does a lot of things. It's a huge law, but it provides guidelines regarding patient privacy and confidentiality. And it's really nice, at least for our purposes, for taking the test and stuff, that we have federal legislation because you don't have to worry about laws from state to state. Now, there are certainly patchwork laws that are different from state to state, but when it comes to patient privacy, it's pretty uniform. And so it is fair game for the test. Typically, the test will not test you on anything that varies from state to state because it's a national test. So they're only going to test you on things that are uniform across the country. Violations of HIPAA constitute unethical practice, and it's also illegal, and that can jeopardize your privilege to practice medicine. And in very egregious circumstances, it can actually be a crime, which means fines and jail time if you're not careful. As a guiding principle in general, you may disclose protected information that you can't disclose otherwise to a surrogate, proxy, or a person designated through a power of attorney if that file is on record. And you can do this without direct consent. So if the patient has on record a certain contact power of attorney, you don't need to ask the patient to if you can disclose that information. So if they have, let's say their wife on file, you don't need to ask the patient, can I tell your wife this, that, or the other thing? It's implied because it's on file. Now, if they tell you, don't tell them. So let's say they have a power of attorney, it's their wife. The guy comes in, he's got erectile dysfunction, wants Viagra. And he says, don't tell my wife. Then you can't tell. Even though that file is on record, you can't tell if the patient tells you not to. Now, on the other hand, if they don't have a power of attorney and they tell you, you can tell my wife or you can tell my adult son or whatever, then you can tell. They don't need to have the power of attorney, but you want to make sure you document it and write that the patient told me I can tell so-and-so. so that if they come back and try to sue you for telling someone that they didn't have on file, you have it documented that they told you could tell that particular person. So basically, what I want to highlight here is that you got to go by what the patient tells you verbally. However, if they have something on file telling you that you can tell a certain person, you don't need to ask again for their permission. So this is a power of attorney form. They all look different. This is just a template, but a lot of times hospitals will have this on record, and typically it'll be pretty obvious in their electronic medical record that they've got a certain person that's a contact. When do you violate confidentiality? And again, I put it in quotation marks here because it's not really considered a violation of confidentiality. These are just kind of exceptions to our general don't tell anyone but the patient and keep it between the two of you. So the big one is threat to self or others. So if a patient voices a plan or active desire to harm themselves or someone else, this is grounds for involuntary admission to a psychiatric unit for observation. So if a patient has active suicidal ideations, if they have active homicidal ideations, you're going to send them to a psych unit. Additionally, if it's homicidal ideations or they plan on hurting somebody else, their kids, their spouse, their coworkers, you have to inform the target that they're endangered. And typically, it's not going to be you who does this. You're not going to get on the phone or look this person up in the yellow pages or white pages. What you're going to do is you're going to consult with your institution's legal department, or if you're a private practitioner, you'll contact law enforcement yourself and let them know, and they'll know how to manage this. Also, reportable conditions. So again, this is always, and this is for public health purposes. So this is not your choice. You don't get to decide, well, it's a reportable condition, but I want to keep this between me and the patient. Or patient tells me they don't want me to report it, so I'm not going to report it. No, this is mandatory. You have to report reportable conditions. The list of reportable conditions will vary by state, but typically it will include HIV/AIDS, syphilis, gonorrhea, chlamydia, TB, measles, mumps, rubella, smallpox, and suspected bioterrorist events like anthrax or stuff like that, which I don't think you'll ever encounter. But that's a list of diseases that are pretty uniform nationwide. HIV/AIDS, I would say, would be the one that comes up most commonly on the test because I think that's all 50 states. So reportable conditions you have to report. That's why they're called reportable conditions. So both these, threat to self and others, and reportable conditions are always report. Minor patients, so usually. So I would say always custodial parents have the right to their child's medical information. So mom and dad, if mom and dad call in and ask, you got to tell them. And you have to tell them. Now this does not always jive with does the child get to make their own medical decisions. So that can be a little murky. But when it comes to a parent, if they ask about records regarding their children, they pretty much have a right to their child's medical information. Now, what about other adults? So what about if the aunt brings their niece or nephew in to the ER for something and you can't get a hold of the parents? Can you tell the aunt? Yes, you can. However, if the parent is available, then you go to the parent. And the reason is because that person is pretty much the responsible decision maker for the child, who really does not have an absolute right to privacy. However, when it comes down to decision making, it's the parents. Now, let's say there's a custodial issue where mom has full custody, dad has no custody. Then the dad has no right to private medical information about the child, has no right to make decisions for the child. It's only the custodial parent. So being a biological parent means nothing. You have to be a custodial parent. And then abuse. This is a sometimes. Now, there are 3 cases of abuse which you'll always report, and then there's one that you can only report with consent. So child abuse and elder abuse always have to be reported when it's just suspected. Even if you don't have conclusive evidence, you always need to report it when it's suspected. And typically you'll get in touch with social services at your hospital and they will take care of this stuff. Now, if it's abuse to the patient, you're taking care of a patient and you suspect abuse, or even if they tell you I'm being abused, you can only report this with the patient's consent. So you've got a woman who comes in, she's got black eyes, she says her husband threw her down the stairs, broke her leg or something like that. You can't just call the police and tell the police that I have a patient who's being abused. You can do that only with the patient's consent. Now, the exception to that is if the patient is vulnerable. So let's say it's a woman who's let's say she's unconscious, maybe, or let's say that she's mentally handicapped, or she's got some sort of mental disability. Then in that case, you need to report the abuse because this would be a vulnerable patient. If the patient is the source of abuse, then you have to report it to law enforcement. So if they're being abused, you can only report it to law enforcement with their consent. If they are the source of abuse, so if you have a guy that says, I'm going to go home and pop my wife one because of this reason or whatever, then you have to report that to law enforcement because that person is a threat to others. So kind of going back to threat to self or others, if they say they're going to abuse someone and they admit that they're abusing someone, then you have to report that because they're a threat to others, be them vulnerable or not. Okay, now dealing with minor patients. So this is not, here we're not talking about confidentiality, we're just talking about dealing with minor patients in general. So a minor is anyone under the age of 18. The treatment of patients under the age of 18 requires parental consent unless they are emancipated by court order. I have never seen that in my entire practice, but I also don't deal with children, so maybe I'm not the best source here. If they're financially independent, so here what I'm thinking of is, let's say they're 17 and they're in college and they're living on the other end of the country. Do you need to call up the parents and ask for consent? In that case, no, because they're living on their own, they're independent. If they're married or raising children, here really I stress married. If a person who's a minor under the age of 18 gets married, they are legally emancipated with that marriage license. Same if they are raising children on their own. In that case, they are emancipated. Presumably, they had to get a parent to sign their marriage contract if they're under the age of 18, so that constitutes an emancipation. If they're serving in the armed forces, I don't believe you can serve in the armed forces under the age of 18, but I got this from a reliable source, so I'm not sure why that was on there, but there you go. If they're requesting treatment for certain medical conditions, then you don't need parental consent. That includes treating anything related to a pregnancy, contraception. So if a 15-year-old girl comes in and says she wants birth control, you do not need parental consent to provide that birth control. If you're treating them for STDs or if you're treating a psychiatric illness, you do not need parental consent. But please, please, please note, and you will not be tested on this, but do note for practice that elective termination of pregnancy does require parental consent in some states. You won't be tested on that because it depends on the state. So because this is a national licensing examination, they're not going to expect, there wouldn't be a right answer because it depends on your state. So that won't come up on the test, but know that for clinical practice. And then I got this from First Aid, so please don't quote me here, but this comes from a pretty reliable test-taking book source. Most questions on the USMLE regarding parental consent will deal with situations such as these here above. So the governing principle should be to let minors make their own decisions. However, just because a minor can make their own decision does not mean that the parent doesn't have right to information on that decision. So if the general rule is if the patient is under 18, their parent retains legal right to their child's information. And really the only exception I can think of here is if they're emancipated, because if a child is emancipated, they're technically considered an adult for most purposes. As far as, I'm not sure, they're certainly not an adult for voting and stuff like that, but they're considered competent to make their own decisions for themselves. And so like I said here, there are times when a minor patient can make their own decisions, But that doesn't mean that their parent does not. That doesn't mean their parent has relinquished rights to their information. So confidentiality typically does not set in until the patient is 18. But prior to age 18, a minor patient is able to make certain medical decisions for themselves. However, on some other things, a parent may be able to trump their child's decision. Typically, it's going to be pretty straightforward. It'll be pregnancy, contraceptions, STD, psychiatric illness is what you'll get. And in that case, you do not need parental consent. So to recap, HIPAA sets forth federal guidelines regarding patient confidentiality. Violations can result in loss of licensure and even legal ramifications. Confidentiality is a critical part of the patient-physician relationship and can only be breached, quote unquote, in rare circumstances. That includes harm to self or others, reportable conditions, child, elder, or vulnerable person abuse, minor patients in most circumstances. And then minor patients should generally be allowed to make their own decisions. However, custodial parents do retain rights to their children's medical information, even if that child made the decision themselves. If you have any questions, write me a note below. Otherwise, I will see you next time.